The power of judicial review is the power of courts to invalidate the acts of the other branches on the ground that those acts violate the Constitution. Judicial review gives courts enormous power. Indeed, most of the most famous decisions of the U.S. Supreme Court are exercises of it. This includes cases you may have heard of, like Brown v. Board of Education in 1954, where the Supreme Court said that race-based segregation of public schools was unconstitutional. Or Roe v. Wade in 1973, where the court struck down state prohibitions on abortion. But amazingly, this power of judicial review is not in the Constitution. Where then did it come from? It came from the Supreme Court itself early in its history in a case called Marbury v. Madison. Unsurprisingly, Marbury v. Madison is usually considered the most important decision the U.S. Supreme Court has ever issued. It was decided in 1803 in the middle of a great political battle between the Federalists and the Republicans. Now, being in the middle of a political battle is not where we usually expect the court to be. How did the Supreme Court of the United States get there? How did it use Marbury to strike a blow for its side without being attacked and destroyed by its opponents? And how, in the midst of this political battle, did it come to assert the power of judicial review? The politics of the 18th century pitted the Federalists against the Republicans. The Federalists supported a strong national government, while the Republicans wanted a weak national government and preferred strong state governments. In the 1790s, the Federalists controlled the presidency under John Adams and the Congress. All the justices of the United States Supreme Court were Federalists. And in 1798, the Federalists dominated Congress, enacted the Alien and Sedition Acts to suppress the partisan activities of their Republican opponents. The courts, including several members of the U.S. Supreme Court, joined in, actively enforcing the acts. The Supreme Court paid for these mistakes. Thomas Jefferson won the presidential election of 1800, and his Republicans took control of the Congress. What did the Federalists do in response? They feared the Republicans, and they had just lost the Congress and the presidency. They desperately wanted to hold on to the third branch of government, the judiciary. Well, first they passed a law shrinking the size of the U.S. Supreme Court from 6 to 5. Turned out one of the 6 justices was dying, and by making the court smaller, President Jefferson wouldn't get to appoint a justice. Second, they passed the Judiciary Act of 1801, which contained several provisions. Among them was the creation of 16 new circuit courts, to which they appointed 16 Federalist judges. These judges are called the Midnight Judges. Second, they created 42 new positions called Justices of the Peace, and they attempted to fill them with 42 good Federalists. And third, they appointed John Marshall, a leading Federalist, as the new Chief Justice of the Supreme Court. Now, all this was done at the last minute to protect the Federalists from the Republicans who were about to take over both the Congress and the presidency. Consider the timing. President Jefferson was to be sworn in on March 4th. The laws creating the Justices of the Peace was passed on February 27th. President Adams nominated the 42 Federalists to fill the position on March 2nd. The Senate confirmed them on March 3rd. Now, there was a problem. All the commissions appointing the Justices of the Peace were signed and sealed, but 4 of them weren't delivered. When Jefferson came to power, he considered those 4 void, and he ordered the new Republican Secretary of State, James Madison, not to deliver them. Now, Marbury was one of the 4 nominated Justices of the Peace who didn't receive his commission. He sued Secretary of State Madison for withholding it. And Marbury argued that once the president had signed the commission and once it had been sealed, he was officially appointed regardless of whether or not he received the paperwork. And he asked the Supreme Court for a writ of mandamus ordering delivery of his commission. Now, a writ of mandamus is a technical term, but what it really means is it's an order from a court to an official requiring a particular action. Now, why didn't Marbury receive his commission? Well, the former Federalist Secretary of State said, and I'm quoting here, "I should have sent out the commissions which had been signed and sealed, but for the extreme hurry of time." The person delivering the commission said that finding in the archaic language of the time that he could not conveniently carry the whole, he returned several of them to the Secretary of State's office. Now, who were these people? Well, the former Federalist Secretary of State who failed to deliver the commissions was John Marshall, now Chief Justice of the Supreme Court and about to hear Marbury's case. The weak messenger who couldn't carry the commissions was his brother James. Clearly, John Marshall had a conflict of interest. The case of Marbury versus Madison was presided over by Chief Justice John Marshall, and the court faced hard choices. It could order that the commission be delivered. This would show that the court was independent from the Congress and the President. It would show it had a role, and it would show absolutely no power, since President Jefferson had made it clear he would disobey any order from the court. Well, then the court could deny that the commission be delivered. The problem here was that this would show no independence from the other branches, no role for the court, and no power. Now, Marshall should have disqualified himself because of his conflict of interest, but instead he outsmarted Jefferson and the Republicans. He had 4 goals in his opinion. The first was to attack Jefferson and Madison for mistreating Marbury and to score some political points. It would also show independence for the court. Second, he wanted to establish that cabinet officers, the Secretary of State in this case, could be sued. This would establish a role for the court. Third, he wanted to establish the power of judicial review. And fourth, he wanted to do all this and avoid a direct confrontation with President Jefferson so as to avoid losing power.